Writ petitions are allowed. Yes, any mention?
Your Lordship, I beg to mention item number 19, 20, and 21.
19, 20, 21. Yes.
I'm appearing on behalf of Deep Pangin. Council is not ready for arguing the matter today.
Why?
He is busy in election petition. He is busy in election petition.
Election petition?
Yes.
Which election petition?
Kariko Karegi.
Okay. Mr.
C. Tajo.
Learned counsel for the petitioner submits the leading counsel, Mr. D. Pagi, has some personal difficulty to argue this matter today. Mr. Therefore, press for listing the matter after 2 weeks. 2 weeks?
Yes, sir. All right.
I think it should be separate orders. It's not analogous. 19, 20, 21. Yes, Mr. 19, 20, 21.
Yes, Your Lordship.
Separate
Yes.
orders, sir.
May I, Lordship? Lordship, I beg to mention item number 8 on behalf of Jumgam Jini, J. Jini, Lordship.
Yes.
He has some personal difficulties today, so matter can be listed on after 1 week, Your Lordship.
What is this is for orders, we'll see. You be there, we'll see.
Okay, Lordship.
May I, Lordship?
Yes.
Lordship, this is a pre-arrest bail by the applicant here before this honorable court, Lordship.
What is the age of the victim?
The age
The
of
complainant.
the complaint is a major, Lordship.
How many- What's the age?
The age has not been given, but Lordship, as per my knowledge, he was a friend of the petitioner hearing. He was a friend of the petitioner, Lordship.
Friend or your, he said
He's a
driver?
not driver, Lordship. He was like a family member in our house, which I have made an abdomen also. Like,
Working as a laborer for Kipa Babu. Page 11.
yes, Lordship. In the FIR it's given, but Lordship, I have been told by the
You are a
petitioner.
former MLA. You should have something. Anyway. Heard, Mr. Case very well. Next week.
Next week.
Yes.
Only case very, Lordship.
Case diary.
Lordship, I have given my statement also, like in respect to this case, Lordship. On like being
You are
called.
granting entry. He has already appeared and is given this. We'll direct them to appear as in when called.
Yes, Lordship.
Or Mr. Vijamo, learned counsel for the applicant. This is an application under section 482 of BNSS 2023. Praying for privilege of the pre-arrest bail in connection with Papu Hills DS case number 46 of 2025 under section 126. So page 1, huh? Call for the case diary. Mr. D. Loy, learned public prosecutor. Enters appearance and accepts notice. No. Mr. D. Loy, learned public prosecutor. Appears for this state. Next bill. Pending production of the case diary in the interim. In the event of arrest of the applicant, namely Kipa Babu, in connection with the Papu Hills PS case number so and so, so and so. Come on. He shall be released on bail on furnishing a bail bond of rupees 15,000 with 102 like amount to the satisfaction of the arresting authority on the following conditions. The accused applicant shall appear before the investigating officer as and when called for. Next, the applicant, the accused applicant shall not so and so that you put that condition. List on next week when? Wednesday? Next day, next Wednesday? When, which date?
130.
30.
Yes. Video blessing.
Yes,
Lord,
madam.
in this matter, the appellant has already paid the degree amount of rupees 30 lakhs to the respondent degree holder. And the IA is,
Matter has become in process.
yes.
Okay.
Process.
Heard MS so and so learned counsel per day.
Lordship, RFA case number 10 is remains, so this may be admitted for hearing. Admitted for hearing. RFA 10,
Yes.
it's remain.
What is not remain?
Now, this for a hearing.
What has
admission,
gone? Huh?
for admission hearing.
You said the matter has become in process.
IA,
Proceed.
that is IA.
Okay.
Yeah.
IA is for what?
IA is for this one.
You write in IA. MS so and so learned counsel per the applicant submits that she's not pressing the IA.
No, IA is for.
She's not pressing the present introductory application in IA, huh? According the IA stands closed. Huh?
Lordship, there is a remaining amount is there. They'll be paid some after 3 weeks.
IA is by whom?
No. IA is for this application for the. IA is
for what? Madam, tell us, what is this? IA is for?
IA is for this the impugned judgment and awarded a 15/9/2023 passed by the learned civil judge, senior division of East Siang district of Pasigat.
Stay of the
For stay.
execution.
Yes.
It has been already executed.
Already executed. And
That case you write, MS so and so learned counsel for the applicant submits that since the present IA is for stay of praying for stay of the execution, and the decree has already been executed, same may be closed, huh? Accordingly, IA states closed. Then RFA?
RFA is remaining.
RFA, what is this? Who is called the respondent?
Respondent is a Kekong Osik.
Who is appearing on his behalf?
Manish AK Misra.
Yes. You are challenging the decree.
Yes.
So, what are the grounds? If decree has already been executed, what remains?
Yes,
Are you sure? I doubt now.
no,
You
there
may not press the IA, but then if we say the decree has already been executed, then it will have a
Lordship, kindly come to the order of 17/9/2024
of what? By whom?
by the this
By this court.
from the
By
civ-
this court.
no, from Civil Judge Division at
Yes.
Pasigan.
Ah.
Here, 30 has been already paid. The only that there is a interest of this 12% per annum, including
So
in that
we'll
cost.
ask you, but
3 weeks.
3 weeks.
Yeah, 3 weeks.
Then we'll
They'll deposit in 3 weeks.
First appeal also. What's there?
No, they were paying some time to deposit the remaining amount.
We'll provide you the 3 weeks time
Yes.
and close the. Are you sure?
No,
See,
no,
let me
not
see.
deposit. This RFA maybe
Let me
for
see
the
that order.
order is already there in. I have already submitted it.
Yeah. 17/9/2024. Yes. Is it the order?
Yes.
17/9.
17/9/24.
17/9.
17/09 of
Yeah.
2024.
Yes. That is. You have settled the matters, everything.
Yes, only the hearing is remaining of this RFA 10. So
Huh?
the RFA 10 is the remaining.
No, you have settled the matter.
Matter is
Decree was
settled.
for 30
Yes,
lakhs
30
with
lakhs.
10 lakhs, 1 lakh litigation cost.
Yes, litigation.
And you have settled the matter for a total of rupees 45 lakhs, right?
Yes.
Matter ends there. Once you have settled, was the question of how you, once you settle and you, how can you agitate it again and again? We'll close it. Do you have an instruction from your client?
Yeah, I was just instructed from my client
Yes.
for taking 3 weeks time for
For payment.
payment, remaining
No,
amount.
payment we cannot. You see, RFA, you are challenging you have challenged the decree in RFA. That is pending now,
Yes.
item 2. And you have filed an IA for stay of the
Stay of
execution.
execution. Yes.
There's no order. So now that has been settled. Now you have been arrested. I don't know how you have arrested. That is not outlook out. But then somehow, in view of the arrest and all those release, you have settled the matter
Yes.
for 45 lakhs.
45 lakhs.
More than the decree. I mean, maybe the lump sum with the decree. I don't know. But since you have agreed settle the matter, so what's the question of? What's the point of hearing your RFA? Okay, that order remains. We're closing it. Yes. Heard MS item 2 RFA. Learn counsel for the appellant. Next paragraph. By placing the non-appears for the respondent, by placing the order dated, a copy of the order dated 1709/2024, passed by the learned Chief Judicial Magistrate, come civil judge within bracket senior division, Pasigan, whereby and placing the sense, not whereby the submits that the parties have settled the matter. And accordingly, a sum of rupees 30 lakhs to RTGS and a check of rupees 15 lakhs have already been issued in favor of the respondent. Please. Therefore, there's nothing, the matter has become. Therefore, the present appeal may be closed. Next, having considered the submissions of learned counsel to the appellant and also perusal of the order dated 17/09/2024, which indicates that the parties have settled the matter for a sum of rupees 45 lakhs to be paid by the appellant to the respondent. I deem it appropriate to close this. I'm of the view that there's nothing and no issue remains to be adjudicated according to the regular past appeal. And as it stays closed and disposed of. Yeah. Are you sure? Before signing, you think over it.
Yes, sir.
Dispose.
Good afternoon, Your Lordship. I am appearing for respondent for petition number 3. In item number 3, for petitioner, my lord.
Yes.
Your Lordship, in this
for respondent number 2.
in this case, my
Yes.
lord, I have filed an IA number 20 of 2025, and on the last date of hearing, the last chance was granted to the respondent to file reply of this IA, and it was observed
Okay.
that if no reply has been filed, it will be considered on made that application, whatever record is available on record.
Yes.
So my peer, Your Lordship, reply till today reply has not been filed. So my lord, make my IA, this IA may kindly consider, my lord.
IA is for what?
IA is for taking additional facts and documents on record.
What is the-
Your Lordship, it is well settled that in criminal proceeding, Your Lordship, it is only the prosecution material which has been collected during the course of investigation has to be taken into consideration. No additional material can be adduced by any party, Your Lordship. So now they have filed IA, which whether the same is the part of the record of the learned trial court proceeding or not, Your Lordship, that we don't know. That can be called out from the trial court record only. And moreover, Your Lordship, this matter was earlier looked after by the SIT, Special PP, Your Lordship. But now SIT, today only we come to know that he has already resigned. And on the last occasion also, Your Lordship, I've seen the order that
SIT.
SIT, yes, Your Lordship.
What is the matter about?
It's a
Your
husband wife
Lordship,
dispute, Your
for
Lordship.
quashing of FIR. This matter is for quashing of FIR filed lodged by the wife against the husband under section 498A and other sections. my lord.
As part of the record, Your Lordship, they had earlier approached the Honorable Supreme Court for transfer of this case also, but which was rejected by the Honorable Supreme Court, Your Lordship.
That was a different matter, my lord. It was petition for transfer of this case because I have taken ground that in the Itanagar, no further action was arise. On the basis of that, I filed the transfer petition to transfer the proceeding of this FIR from
Sir-
Itanagar to district Gwalior.
Sir, where are
It
you
was the
from?
difference.
Sir, where are you
I
from?
am from Gwalior, Gwalior. Yeah, my client also belongs to district Gwalior, the state of
So
MP.
it's not compatible from BC. You visit Arunachal? You appear in person before the court? It's
No,
not
I am the
compatible.
counsel. I am the counsel.
Yes,
I am appealing on behalf of my client.
that's what I'm saying. You
Yes, my
appear.
lord.
Come to Arunachal, come to Itanagar.
Actually, my lord, last two occasion I came here, but and what is happening, my lord? Each and every day they are seeking time. Till today they have not filed. So my visit at or Itanagar,
No, what I'm saying
if
is,
council has been
okay,
completed, my lord. After completing of council, completing
we-
of
sir, we
my
cannot deny you through the BC, but then it's not compatible. We're not, court is not compatible with through the BC. It's very difficult.
my lord.
If you want to take risk, up to you.
My payers,
Yes.
lordship, for final hearing,
Your Lordship.
I can come, my lord. But today, my lord, my payer that this IA may be considered, my lord.
Your Lordship,
That
we have
IA may be
objection to their
considered on
petition
BC, my
and
lord.
their IA. We have objection to their petition and as well as their IA. So we may be given time
So
to.
you have not filed this last answer is given. At least one day prior to next date of listing with a copy sent by you to the.
Your Lordship, the conducting counsel for the respondent is also out of station, G. Talo. 1 week time will be given, we'll submit a written objection.
My lord, on the last date also, they have taken time to file reply of this IA on the basis that counsel is hospitalized. And the last date, my lord, without informing me, they were trying to take adjournment without informing me, my lord.
Mr.
So it is,
Rohit Zakwani, learned counsel for the petitioner.
my lord.
Petitioner. In both the cases,
Your,
And second case, my lord, I am for respondent. That has been filed by the wife. Connected item number 4. That has been filed by
Yes.
the wife, my lord.
3 is by you.
yes, Your Lord.
Yeah.
And in this petition, my lord, they are enjoying the interim relief. So in that matter also, I have objection, my
prayer
lord.
of Mr.
VT Gurum, Your Lordship. VT Gurum.
Swing,
Gurum.
learned counsel for the respondent number 2. List this matter after 2 weeks. So as to enable. No, on the prayer of Mr. So-and-so, learned counsel for the respondent number 2. Further 2 weeks time is granted for filing objection, if any, as a last opportunity. Mr. Next para. It is submitted by Mr. You are not a party here. It's not a
Respondent
SIT.
1. Your Lordship, state is party, but SIT was the necessary party.
Mr.
We are performing.
Create learned additional PT for the state submits that these matters are being dealt with by the state. What is
Special.
who had a separate council? However, it is learned that the council for the SIT has already resigned from the post. In view of the Mr. Theatre learned Edison PP to obtain instruction from the SIT.
Yes, sir.
List after 2 weeks. We're taking up
Malak-
2 weeks.
My lord, any fixed date may be given, my lord, because I'm out of
Very
fixed date.
difficult.
Your Lordship, may kindly give the fixed date, my lord.
Yes, after 2 weeks, give the date. After 2 weeks. You tell us the date. 5th of May,
My lord.
05/05/2025.
My lord, item number 18 also there is also between the same party and same council.
Your Lordship, item number 4, Your Lordship, we are the petitioner in that IA. As informed, they are not making the payment.
Item number 4.
Yes, Your Lordship.
Okay.
The IA is regarding monthly maintenance of 8,000 rupees. As instructed by the client, they are not making any payment, so they may be directed to file an additional affidavit where they can prove that they are making the whole payment.
In item 4, huh? Not Mr. So-and-so, Learned Counsel, appearing on behalf of Mr. Jitalo,
Yes, Your Lordship.
Learned Counsel for the petitioner. And you are here as a respondent number 2.
My lord. For respondent, sole respondent. Sole respondent, my
We
lord.
are not the party here.
Sole respondent, huh? So-and-so, Rohit Jagwani,
Right.
respondent number, sole respondent. Huh? This along with this. Criminal petition 157 of 2023. Yes, whatever.
Item number 18. Yes, my lord.
18 is what? Same.
Your Lordship,
Or
item
Mr.
number
So-and-so.
18. My lord.
On the prayer of Mr. Rohit Jagwani, Land Council for the petitioner, list this matter along with criminal petition 157 of 2023. Yes.
In this petition, my lord, they are last date, they have 6 time to file reply. But in this matter also, they have not filed reply.
Thank you,
The
thank
council-
you, thank you.
Your Lordship, we have not
It will
received.
be taken up on 5th along with that earlier. Yes.
Obliged, ma'am.
Yes.
Your Lordship, this is a criminal petition praying for setting aside of an interim order passed by the Judicial Magistrate First Class UPR in
Where's
a
the-
maintenance case.
Where is the interim order? Where's the interim order?
Interim order, page number 83, Your Lordship.
Hmm?
Page number 83.
83. Yes.
Your Lordship, by this order, the Honorable Judicial Magistrate First Class has directed the respondent to pay amount of rupees 25,000 as an ex parte ad interim
Hmm.
maintenance.
Yes.
Your Lordship, where is Your Lordship? This, while filing this application, maintenance application, the respondent has not given the correct information.
Hmm.
It is clearly in their maintenance application. Page number 23, Your Lordship.
You hesitate before the court. It's a interim direction on.
Your Lordship, to modify and alter the interim order, we have filed a misapplication.
Yes.
However, that misapplication was dismissed on a technical ground, citing that there is no change of circumstance. Whereas, Your Lordship, when this interim order was passed, it was passed ex parte during the pendency of the notice.
So you get it disposed of.
Your Lordship, already the misapplication has been disposed of. No
Now-
change.
The main get the main application disposed of.
Yes, Your Lordship.
So
So Your Lordship, difficulties here, the respondent is earning rupees 60,000 per month.
per month.
Per month 60,000.
Okay.
Out of that, he is paying monthly EMI of rupees 27,000. And 5,000 interest rate toward a loan taken from a private agency. So after deducting this amount, he is receiving only 27,826 rupees in hand.
Why not concern? whether you have taken a loan or whether you are receiving. But
Your-
facts remain that your gross income is 60,000.
Yes, your
You are
lordship.
working
As a constable, I am. Your lordship,
wife is
now wife is not working.
not working.
However, your lordship, I'm looking after the education, all the responsibility of the two elders son, as well as your lordship, prior filing this maintenance application, I was paying maintenance.
just wait. Yes.
Your lordship, currently I have given my elder son in a private school. There is a very well reputed English school, private school. So a monthly school fee is rupees
That
75,000.
will be finally settled in the main case, main petition. It's an interim. If you
Your lordship, after
if you insist, we'll enhance it. 30,000.
no, your lordship, after deduction of 25,000, only 2,000 remains with me.
If you insist, we'll enhance it. 30,000.
Your lordship, a fair amount may be fixed.
No,
because-
25 is. I think it's the fairest.
No, your lordship, respondent, the petitioner is duly
You
taking,
have two children.
yes, I'm taking the responsibility of
That
the
will
two
be
children.
settled. That will be finally settled. It's an interim matter. If you insist, we'll enhance. Around 30,000. 5,000. It's an interim.
Yes, it is
You
an
get it
interim,
settled
your
in the final petition. That will be adjudicated whether yours is entitled or not. And if you are they're saying that you are looking after the children, your expenses are being borne by you for the children, that will be settled by the appropriate court. You are just against the interim.
Yes, your lordship.
So if you insist, we'll enhance.
Your lordship, at least fair amount may be fixed, your lordship.
25,000.
Yeah,
That's
as
why I
of now-
said,
As of now, your
I've said
lordship,
according to this code is the fairest.
your lordship, as of now, he is remaining with only 25,000. That is not at all sufficient to maintain his.
You get the things settled before the appropriate court. 25 is enough. You are earning, we don't know how much you are, what is your liabilities and all. You are admitting that it's a 64,000.
Yes, your lordship.
Your
Your lordship, come to page number one.
Your gross income in the salary is 64,000.
No, 60,000.
No, it
Yes,
said
your lordship.
64,000. Where do you say that you saw the document that your monthly income is 60 gross?
Page number 154.
154.
Yes. The last portion, 60,587 rupees.
150.
154.
Net, gross, gross is 66. Your gross is 66, 363. Net is of course 60.
Net is 60. And you'll also see page number 107. Kindly come to page number
107.
107. Yes, sir.
107.
Yes.
Yes.
SBI record, the bank statement record that he has availed loan of rupees 13,000, 13 lakhs 99,400. And you will see this loan is something that he has not taken for his own personal use. Under compulsion, he has availed this loan. You will see when there was no dispute.
You are a husband.
Yes.
You have 2 kids. You have to pay the piper. Can't help it. Yes, madam.
My lord, I'm appearing on behalf of respondent, my lord.
Can you have any sympathy? I mean, as a wife,
No, my lord, in fact, this is a disputed matter.
increasing, 5,000.
No, my lord, since both the children are with me, my lord, and the second one, now he has become 3 years. So it's impossible for me, and my lord, without going into the merit also, my lord, merit of the case, they have challenged the order of the lower court, saying that if they have if the interim order was rightly passed or not, my lord. So on that basis, they haven't challenged that. Number one. Number two, they have said that they have challenged in the lower court for the modification of the interim order, but they have not shown there that what changes have been brought. In fact, they have only shown the liabilities, my lord. So, my lord, I think the lower court has rightly passed the order, my lord. And in this court, they have only come with the prayer of ad interim and the modification of.
You know, see, the interim order was passed completely it was
No,
passed
see, for modification of the interim, there must be some change circumstances. You have not been able to show that.
Yes.
Before before the court. So rightly dismissed. You are not challenging that. You are not challenging that.
No, we are not challenging.
It cannot be challenged. It's not available.
Yes, it is not available. Yes,
is it, sir?
Yes.
May not be available, but it can be challenged. But then anyway, that's not the issue.
You will see there is also a requirement for filing of asset affidavit disclosing asset and liability. So to enable the court to determine
It's a good ground for you. You get it settled there before the magistrate court.
you must see, considering the financial liability of the respondent.
That's I said, you have to pay the piper, nothing else. You are the husband, you have two kids, you have to manage it.
I have given, it is not true that the 2 minor sons are with the
That's why that
respondent.
will be
I have
established
given,
whether you are, you are bearing the expenses of the kids
yes, your lordship.
or whether there is a liability, whatever, whether that will be decided by the magistrate court, not by us. All right.
Your lordship.
If you insist, I have indicated will increase another 5,000.
Your lordship, other than approaching this court, I do not have any remedies now.
That's what I'm saying. I'm not saying that you don't have a right to approach this court. And the facts of the case, what I'm saying is, you have 2 children. Have you been divorced? No.
Not divorced.
You have not divorced also. You have neglected.
Not neglected, even not neglected. There is a dispute between
There
the
is no way
respondent and
of
husband.
Then to catch hold of you.
Yes, your lordship. And I have never shy away from my
Catch hold.
responsibility.
Yes.
I have never shy away from my liabilities. Finally, fatherhood liability. I was always there because of the
So what about the wife?
wife. Even the wife is staying in the
In your
petitioner's
house?
mother's
Huh?
house. Petitioner mother's house.
So it's good.
In laws.
You settle it, and you settle with your wife. Rest will follow. No trouble. You can I mean, freely pay your loan, whatever is there, unless you are.
You know,
So,
even if this, there is already a provision 127. If in later stage, if the financial status of the respondent is improved, then anytime the respondent can file an application
you
for the
edited
enhancement.
all this thing before the magistrate court, not before us. You find this 25,000, your income is 60 lakhs, fair enough.
You also come to the impugn order. Kindly one look,
I've seen it.
the last impugn order passed in this case. It was not taken into.
This is also an impugn order.
Yes,
Yes, where is
For the model.
218.
200?
218.
18.
218. I'm reading the operating portion.
Yes.
However, the petitioner respondent has failed to show any change in circumstance. This circumstance which has presented is the same as that prevailed during the ex parte and interim maintenance was granted. A perusal of the record and submission of the counsel of the petitioner respondent shows that the mother of the petitioner respondent is a government employee herself with sufficient income. As such, in light of any change in circumstance, I do not deem fit to allow the prayer.
Mother of the petition is a government employee. Yes.
You know, see, when this misapplication was filed, the court below has not taken into consideration of the financial liabilities of the respondent.
What the mother has got to do with it? Whether he is a government employee, whether she is earning enough.
My lord, in fact, the respondent, petitioners here, they have sought some medical certificate saying that he has also the responsibility of the mother.
Okay.
As such, the judge has pointed out that.
You know, see, here it is a fact that the mother
We don't find any wrong, any illegalities.
you know, see, kindly take note of the
I have
loan.
taken note everything.
Yes.
That's why I said
This loan was
this
able.
code is of the view that it is less, rather it is lesser. It should enhance 50% at least interim.
You know, see, these loans were jointly taken by both of them. When they were together, they have started a business.
That's why I'm repeating. Because you introspect yourself. Whether you're together, not together, your personal loan, whatever, we're not concerned. Now, since you are the husband, you have 2 children, you have married the wife, you have deserted the wife, you have to pay the piper, that's all. Nothing else. Sir, better get settled the matter, whatever you are raising here. It's, as she has rightly pointed, it's all a factual thing. We are not going into it. We looked into it whether this order is fair or not. Interim order, nothing else. That has been finally settled. You may not have to pay a single penny also, finally. All right. So, dismiss.
Your Lordship, 20,000 maybe last fix. Because Your Lordship, 2,000 is not, it will be unfair for me.
What do you say?
My lord, but they haven't come for the enhancement or this one. They have challenged the order of law.
In the
Also,
prayer portion, I have specifically seek
No, no,
for,
it's okay. I'm just asking for your.
for
What?
refixing of the interim amount.
And in fact,
I have made the prayer.
my lord,
Momentarily, for your satisfaction, I'm just asking.
my lord, in fact, if you want to save the money, you can leave the rent house. You have left the wife with mother and is staying in the rent house. Save the money. Save
No,
the
Your
money.
Lordship, because my posting is in Itanagar. So every day to avoid the daily expenditure.
Anyway, we understand everything. So issue is whether the interim order of 25,000 is fair or not. That I find it's very fair. It's fair. It's the fairest, and it has not been finally settled how much you have to pay. There's a scope. You may hesitate and place everything whatever you would like to before the a court concerned. So
Your Lordship, 2,000 is not sufficient to sustain my even basic needs. 2,000 is very.
can help it. We don't. Myself doesn't know how much we have in our pocket. Let's say it's a 2,000 is big enough. We don't carry even 5 or 6 and not more than.
Your Lordship, reduction of 27,000 is not disputed. It is a fact.
That you agitate before the court. The court concerned, you agitate all this thing. It's an interim. Don't get it multiplied. Better you, concentrate on the main petition. You get it resolved, get it disposed of, get it concluded. All right. If you insist on this interim, may prolong. So get the petition resolved. You are the respondent there.
Yeah.
You get the petition adjudicated by the concerned court, matter ends there. Then you have a remedy afterwards. All right.
But Your Lordship, this proceeding is likely to take a longer time.
What longer time?
A long time. The maintenance proceeding before the JMFC.
So therefore you are to make it shortcut, you are approaching this court.
No, Your Lordship, before I have approached, my difficulties has not been taken into consideration while disposing my misapplication for the alteration. Therefore, Your Lordship.
That has been rejected. So get the thing settled. Yes, that's all.
Your Lordship, while passing this order, interim order, they have not followed the mandate guideline laid down by the Supreme Court in the case of Residence versus Neha. So, Your Lordship, affidavit was not filed.
It's okay. Third, Mr. Dismissing it, huh?
M comes up.
Huh?
M comes up.
M comes up. Learn counsel for the petitioner. And also had MS H. Jerem learned legal aid counsel
Your
or
Lordship,
sole respondent. Yes,
I may be,
the full respondents.
I'll withdraw.
Why? I'm not forcing you. I'm just dismissing you. Anyway, after arguing the matter, at some length, Mr. Kamsel learned counsel for the petitioner submits that he may be allowed to withdraw this criminal petition with a liberty to approach the concerned learned court for adjudication of the maintenance petition. That's why I'm adding it, so that you can pursue that. In view of above, the criminal petition stands closed on withdrawal with a liberty to pursue the maintenance petition pending before the learned judicial magistrate first class, UPR. Please stop. Are you paying it now?
Yes,
You are receiving. You don't know.
Yes, my lord.
Is he paying? The 25,000.
He's paying, yes, my lord.
It's
He's
okay.
been paying.
It's okay. It's okay. That's Sir, I am not forced you. It's up to you. Otherwise, we'll decide. And we're not the final arbiter. We're not the final court. You may approach whatever orders you. All right. It's up to you. Just because you will be just because you are not persuaded, you should not withdraw the petition. It's up to you. All right. And we cannot say that you should not, withdraw also. We decide to the best of our knowledge and ability. We're not the final arbiter in the world. All right.
Yes.
Okay. Thank you.
May I finish?
Yes.
Chief? My lord, item number 6 and 7 may be passed over.
Why?
My senior counsel is court number 1. His
What
commission
is
is
there?
going on.
What is there?
Item number 6 and 7, my lord.
Lordship, on the strength of interim order, they appear before the IO and they are complying, Lordship.
Your Honor,
Do
I'm for the
you
informant.
have the case there?
Yes, Lordship.
What is there? You sure? You tell us what is there.
Your Honor, I'm for the
They
informant.
are complying, Lordship, as and when called, as and when called by the IO, Lordship.
They are cooperating.
Yes,
They are
cooperating. Yes,
cooperating.
yes, Lord.
I'm for
It's a what is the issue?
the,
It's a civil dispute.
Your Honor, this
The
case-
main dispute is land dispute,
Yes.
the ownership of the land.
Yes, Your
So
Honor.
there is a fight between two groups.
Yes, Your Honor. And that,
We're not, quashing this
no,
criminal.
Your Honor,
It's a bail.
that the accused, more than 33%, they came to the incident spot. And yes, one video is
Yes, he's seeking for some time.
Your Honor,
We'll take it after some time.
I may be given some time to file written objection.
What
And
is
this
that
case will be-
objection, sir?
this case will
It's
be
a
taken after some
anticipated.
days.
See, we're putting, the PP is fairly saying the arrest and everything is for fair investigation, right?
Yes, Your Honor.
It is not for punishment.
Yes, Your Honor.
So it's in the bail stage. It's basically, we understand.
Six
That
people have
will
been
be
convicted, Your
decided,
Honor.
that will be decided after the investigation and the charge sheet is after the trial only. Whether you are right or they are right, whether they are criminally liable, whether you are liable or they are liable, that will be after the trial only. So at this stage, we find that since they are cooperating for fair investigation, so we find it.
Your Honor, the granting of bail to them, there is a highly.
Are you a party? Are you a
Today I have
party?
filed wakalanama for the informant.
No, are you a party in this thing?
Uh,
In a bail application, you are not a party.
I'm not a party, but I'm for the victim, Your Honor.
No, it's in not all the cases you will be heard. You just have to assist the PP. In certain offences, it is a settled position. All right. You are not inclined to grant you a time. We are rather inclined to make the bail absolute with certain conditions. Whatever you want, whatever condition you want to be put in,
Yes, Your Honor.
you may suggest the PP.
Your Honor, here is only I have.
You
a-
suggest the PP, you assist the PP, that's all. It's not all the cases you are to be heard.
Yes,
In
Your
certain offences, you have to be heard, but these are all, what is the section? What is the offense?
Honor. Attempt to murder.
Attempt to murder, Lordship.
Also, I'm.
Why you have,
I was
made,
in, I think.
why you have made an attempt to murder?
Also, actually, the fact of the case is that there was this land dispute within the intra clan, the Tagru clan, within the family only. So what happened on 20 since 2000 since 2 years back?
You
This
know,
land dispute.
he's asking for a time to file objection.
No, Lordship, see, Lordship, in AB number 8, that Tagru Anand.
Hmm.
He is also victim of this case because he was attacked and he got severe injury and the medical treatment from the RKMS.
Have you filed any FIR? Is there any counter?
Yes, there is counter FIR there. And also, moreover, now,
So you are safe.
No, Your Honor.
so
You have
investigate.
filed a complaint against him also.
So some of the person they filed a complaint against.
No, complainant. He said he's representing the complainant.
Also.
Have you filed complaint against him? Any FIR against this person?
There is FIR, but not
Who is
by
the
this
complainant
victim.
here?
Victim,
Item 6.
I think
right.
6. I think 6.
Where's the FIR?
Also, page number FIR is page number 10. Page number 10. Is the FIR written FIR
So many
filed by
people, huh?
not so visible. Now,
This is
now,
my home.
type 1 is 27 page.
Tagru Tame,
Tagru Tame is complainant.
complainant.
Tagru Tame is complainant.
So you are for Tagru Tame.
There's two counter complaint is there. In both the case, the name is Tagrutame. In one case, where I am complaining, and there also I am Tagrutame. And where I have been complaining, there also complaining is Tagrutame. But father name is different.
Different.
Yes.
This is Tagru Tame, son of Tagru Tajak. Your
Tag-
name is?
My name is
Other-
Tagru and I'm applicant here.
Okay.
AB. I haven't actually in this case, what happened now? We have to brought the fact of the case before this court, so that this court can pass an appropriate order. Since there is land
It's a
dispute-
bail application. Why do go into all this thing? We find that if custodial inquiry
So, Lordship, I have
extradition is not
already, I have given,
grant you bail
I have already given my
with certain
statement.
condition.
I have already given my statement before the IO.
That's what he is.
And everything, all I think what CB says, now we have to go through that only. Since
If this honorable
the
court-
bail is rejected, then there will be irreparable loss
No, what he's seeking is he wants to file an objection.
but that's not necessary at this stage because this is Honorable High Court. So objection, filing objection will be, it will be put on exercise because investigation and judiciary should go independently.
Why
So
you want
that-
to file an objection? Why?
Your Honor, here in this case that we are all eyewitness are here. They are also Tagru people.
What is the
And-
nature of injury caused by them?
Six people they have been admitted to the interims. Among six, three have been admitted to the ICU, and two is still fighting for the life, and multiple bullets have been shot
We'll
to the.
see from there. We'll see then. At 2, we'll continue. You see the medical report. Find out collect the medical report. How many injured? What is the extent of injury? We'll see. You assist him only. Will not hear you. All right.
Okay.
So next chief. Let us see. This is called the next item.
This is the same item,
No, no.
oh, eight. Oh,
8, yes. Somebody made a mention this morning? No, made a mention, item 8. Yes.
Yes.
What do you want?
Adjournment for today, Your Lordship.
Okay, so this, you have, the respond number 2 and 3 service is complete.
Three, we have taken through paper publication, Your Lordship.
3 only.
Yes,
What about 2?
two is completed, Your Lordship.
Huh?
2 is completed.
Okay. No, heard Mr. So and so learned counsel for the petitioner. Have you filed the paper publication?
Yes, Your
affidavit?
Lordship, we have filed that.
The petitioner filed an affidavit of proof of service upon respond number 3.
Yes,
of
Your
paper publication, which is taken on record. The perusal of the newspaper publication indicates that same was published on 24/09/2022 in Arunachal Times newspaper in Beerwoo. Service report in respect of respond number 3 is complete. It's after 4 weeks. 4 weeks.
2 weeks, Your Lordship.
2 weeks, yes.
Yes. Oblige.
Next. Finish the order. What is to be done today? Service environment to OCPS history same is 20. Receipt, huh? Service complete.
Complete, my lord. I was informed by
In respect of respond number 2.
2 miles, complete.
Yeah.
Yes, my lord, here, I only concern is, Your Lordship, IA for suspension has been filed and the court has pleased to pass an interim order on IA. So what my humble prayer would be, Your Lordship, since they are already protected, suspension, sentence has already been suspended, but the IS is still kept pending, Your Lordship. This is the issue.
It's okay, we'll see. Today we'll just on service, right?
Okay, Your Lordship.
And Mr. El Permen and consent for the appellant. And Mr. Theater and the additional people. Office note dated. No, it's a long term back. Sorry.
Morning, my lord, I was informed by one counsel, my lord, he will appear, my lord, but he is not. Morning, I was informed, my lord, somebody.
No, in that case, it's on the long term back.
No.
Just last order, office order, we'll see. No, the record has been received.
Okay.
Office note dated 04/04/2025 reflects that the original TCR is received. Then in that case, to
Paper.
prepare paper, restitute, a paper would be prepared. List after 4 weeks.
In IA, my lord, there is an interim, my lord, that may be kindly continue, my lord.
In the IA, so and so, her so and so. Why? That's why he's correct. One day IA is interim order is why this should be kept pending.
Yes, Your Lord, it may be disposed of since he is already protected. Suspension has already been, sentence has already been suspended. So, Your Lordship, this IA may be disposed of, Your Lordship. Till the disposal of this appeal. He is convicted for kidnapping only, Your Lord.
In the return left on same terms and conditions. Huh? I will keep it pending.
Okay, Your Lord.
Interim order passed, so and so. still remain, I mean, interim order was, interim order to continue.
In IA, yes. Obliged.
In IA, huh? Hard so insurance.
Your Lordship, I'm for the appellate in this case. We have filed a condemnation of delay in IA 85 or 24. Your Lordship, on the previous occasion, this court was of view that amicus curiae would be appointed if the victim's counsel do not appear. And the notice has been served to the victim.
We'll see. We'll resume at 2.
Last time भी check किया था.
कौन करा के?
My lord, this is a case relating to following PS, case number 08/2025, registered under section 109, clause 1/118, clause 2/3, clause 5 of BNS Act 23, with read with section 27(1) of Arms Act 1919. My lord, this is the case. The applicant is one Tagru Anand. The fact of the case is that on 23/3/25, there was the land dispute. The informant, they were forcefully engaging themselves in the dispute land. So on 26, again, they were doing forceful activity. So what happened? The victim, they went there to stop because they all are belong to same family members. So what happened on 26? When the applicant reached on the spot, then there was altercation started, and they attacked to the applicant Tagru Anand. So and he got injured in the right arms. Serious injury. And that was your injury mark is annexed here within page number. Page number. Page 35. Finally, there was the page 35 also. This right arm was seriously injured. Then the applicant along with those informant, they were shifted to RK Mission on that very day of 26 from place called Nyomi under Karadadi district Palin Circle to RK Mission. Thereafter, again, this applicant they were shifted to St. Luke Hospital, Dibrugarh. Then after on in last occasion, this court intervened and interfered, and protection order was passed. And accordingly, as per this protection or interim order, the applicant, who is the victim of this case, appeared before the concerned IO and given the statement and all the available the witnesses of that incident. He has already given the statement, fully recorded by the concerned IO. So now what happened in this? He is victim since he is under medication, and as per the medical report, given by the St. Luke Hospital, Dibrugarh, and on the 21, advised to take rest for 3 weeks, adhere to treatment, follow diabetic chart. So 21, that's few days back, the doctor has prescribed him, the applicant, the victim applicant, to take rest and take full medication. Otherwise, since his right arms is seriously injured due to the infliction caused by the impairment and others. So therefore, in this case, since the investigation has been completed, Lordship, almost completed already, statement is recorded, and bail bond has been executed as per the direction of this court. So Lordship may absolute the bail order passed on the and moreover, Lordship, in this case already seven person has been enlarged on regular bail from the regular bail by the learned Session Court 0, 4 of, and this court has also regularized 3 of the accused person which is contained in the same FIR. Lordship. Moreover, and 3 is already filed before the learned Session Court 0, and interim has been granted, and the matter speaks for tomorrow at the 0 District Court. So here, since the investigation, whatever the statement has been necessary to be given, the accused person or alleged accused person, either the applicant has already given the full statement and fully cooperated and ready to cooperate on medical ground, the earlier bill order may be obsolete to the applicant, basing on the medical report. And here, Lordship, and there is a counter FIR filed by the victim and applicant here. There is counter FIR in this case because since she got injury. So
Where is the counter FIR?
Counter FIR, page number 21. 21, this Tagru Anand, that is page number 22, serial number 6 is the let's say serial number 6 is the Tagru Anand, the applicant.
1912. What is the FIR in the?
This was earlier FIR, this because prior to the incident. The main FIR is Lordship in type copy, page 27, 325. This is filed by the informant.
Page 27.
27 type copy. 27 type copy. This is the FIR, the content of the FIR filed by the informant. What's the page? Page 12. Page 12. Yeah.
Page 12.
Page 12 is the type copy.
12.
Page 12. Page 12. 11 is the FIR filed by the informant, and 12 is the FIR type copy, clear copy. The FIR is filed by one Tagru Tame. Tagru Tame. There is 2 Tagru Tame, Lordship. This is one FIR, and another in this FIR content accused is also one Tagru Tame. There's 2 Tagru Tame. The FIR is to the officer in charge police station, Palin Police Station, District Karadadi, Arunachal Pradesh. Subject FIR against Mr. So and so. Here, Tagru Mai and Tagru Anand name. The applicant, there is the item number is 6 and 7. These are same which is contained in the FIR. That is, one is Tagru Anand and another is Tagru Mai. So FIR goes like this: FIR against Tagru, Taha Tagru, so on. Total of 21 person. Yes, forcefully entering the land of the victim is named below it Nyomi under Tali Circle with loaded gun and mustache in arms. There's with on the 26/3/25 at 8 a.m. and blindly without any provocation open firing and wounding the innocent person, namely so and so and so. So these are the name of the person. We all have suffered grievous injury, both internal and external, with bullet and mustache cut, knuckle down in whole body parts on the 26th at around 8 to 9 a.m. at Nyomi area under Tali Circle, Karadade district, leading to the airlifting of the said person in Trims Hospital at Naharlagan in a very critical condition. Lordship, here, what happened, this applicant, Tagru Anand, he was also injured. And he was also seated in the same helicopter. And they were brought together at, since this is civil nature, civil dispute. The incident arises out of the civil dispute, particularly at Nyomi area. So there is no any criminal intention and motive to the incident might happen out of emotion or out of angry or out of provocation by someone, not by the
Your name is not there.
Tagru. My name is here.
Where?
Tagru Anand. Here in 1, 2, 3. 9 line of the page number 20.
Which FIR is being, which case you are seeking a bail?
Palin PS case number 08.
Which one? Page? Page.
Page number.
Page 12.
Page number 12.
Huh?
Page 12.
Yes.
Page 12.
Page
So-
12.
1, 2, 3, 4, 5, 6, 7, 8, 9. Ninth line here below. This Tagru Anand, son of Tagru Tare. Subject column. Tagru Anand, son of Tagru Tare. So informant has randomly filed the name of the person. Some of they are not involved actually. Some might involve. Really, they might inflict injury due to the altercation or the things. But now also here the Tagru Anand, the applicant in the applicant is actually victim of this case. He's also got injured and he was airlifted from the same place of occurrence with the informant party. So they were under medical treatment for almost 2 weeks at outside of the state.
What about any injury report?
Since the medical report was not in the case study, so I personally talked to the IO. So medical report is injury is grievous loss. Victim
Yes,
of
loss
injury.
applicant is also lots of in the
But also grievous. Yes, from Karadadi district. Huh? Which one? This is from where? Huh? Who has given you? It's not in the It's not in the
Yes,
case
not
diary.
in the, I personally talked to the IO. Then he
Your Lordship, in this case, I am also victim. I have a I
What
have
is your medical?
medical report. Lordship annexed here in page number 24. 24, the annexer C, page number 24 also. Even on the 26th, I was admitted at RK Mason. And thereafter, in the very evening, because since I am also in critical condition, so I was shifted to St. Luke Hospital at Dibrugarh in page 25, Lordship. Page 25. Subsequently, I was there for almost 2 weeks. Then I filed a AB because police was chasing me. So on 19/3/25, this Honorable Court has granted a protection order. So I appeared before the IO. And accordingly, as per the procedures, I have disclosed everything. All this is cooperated the investigation officer. So, Lordship, I am ready to cooperate. So on health ground, I may be my interim bail order may be made obsolete. Otherwise, it such in injury, I cannot be again in the police custody since I'm fully cooperating, and all statement has been recorded, bail bond has been executed, and moreover, I'm ready to cooperate. Whatever the investigation officer or any court asks me or direct me to appear, fully I am undertakes to cooperate the investigation. So there is no further anything to say before the IO. I have already disclosed everything, Lordship. So since I am a victim of this case, and since I'm in the medical and the medical service, and Lordship may kindly peruse the medical report recently issued by the St. Luke Hospital. And I'm advised to take rest and take a full medication. And moreover, Lordship, and Lordship, page 35, Lordship, page dot injury. You can, your Lordship may kindly see the injury I'm inflicted.
Yes, what do
My bone marrow has been come out. Bone marrow, Lordship. Bone marrow.
as per the observation of IO, their custodial inquiry is not necessary since they are cooperating.
Okay. Why? The IO says that custodial interrogation is not required. What more you want? What more? We'll allow you to participate. What more
Yes.
you want to say?
No, this case was a very serious case. And some of case has not happened in our state. Then more than 30 people, they come here at the place of operation. Wearing some.
See, what about the counter case? FIR.
Not in the civil process. Just mention that the counter. The applicant.
This keep with it.
Such injuries.
Injury is grievous injury. Who is absconding? Out of 22. Who is absconding? Huh?
There is one possibility of increasing the sampling the investigation. All the eyewitness, they are belong to the same community. Because of that, if some way emotions or into some rapport, there is possibility that that witness may get temporary. And you know that the one family member all having after that again when they are told again this they came here and one lady was also there. She was also very beautifully and that the applicant that good thing they have filed one representing before that they are not satisfied with the investigation process of the investigation. And your one person is still at ICU and he is at unconscious state. I will have him apart from
By whom?
by this person. And
This person? Tagru Anand?
yes, he was also there in sport.
No, who has, as of now, according to you?
Your number of bullets you was there. And more than that, they are all blindly and some
There are 22 accused person, out of who has fired the bullet?
and this accused person, he came here in sport and he cut a smoke with down with this one of the victims. And
He has also received a serious injury. I mean, previous injury.
from the open firing as the accused person.
That we don't know.
Here is one video clips of this case. When the father of the old victim, he ran and begging, please don't hurt us. Meanwhile, then there was open firing and that video cannot be captured.
Cannot help it. This at this stage it says for arrest only. The IO has clearly said that no custodial interrogation is required. What can we do? What can we do? It is bail application. It is up to the IO to know whether their custodial interrogation is required or not. In fact, they have. He has been interrogated.
Yes.
Where is his statement? Where is the statement of the accused? Tagru Anand.
Tagwan. Applicant Tagwan.
But admittedly, it's out of the incident has arisen out of land dispute.
Land dispute, lordship, land dispute. Civil nature totally. No motive and intention. Because
No,
of the
That
and
we cannot.
lordship.
Tagru Tadik, Tagru Takap Tagru, Taha Tagru, Tagru Suraj. How many persons have been granted bail?
Now,
Huh? Rest?
I'm not aware of that.
What about others? Because according to the police, 21 have been arrested and released on bail, including the
also I'm ready to cooperate and abide by any term and condition imposed by this honorable court. Since I am also victim of this case, and if my bail is not granted,
No, you are not victim. You have attacked the other group and then you in Italy. I mean, in the process you have counsel for the complainant. In fact, it's not supposed to hear you, but then I have heard you. Place of occurrence so as to persuade the parties to maintain status quo
Yes, sir.
of the land
Yes, sir.
as decided way back, as decided 2 years back. Therefore, there is no involvement of the accused applicant in the alleged attack with the victims public complainant. Mr. Next para, Mr. Number non-consent submits that pursuant to the interim bail granted by this honorable court, the accused applicant has already appeared before the investigating officer. How many times?
Twice.
Are you sure?
Twice is,
Be sure.
I'm known that they
Go
call
to check the
once,
Sure.
once,
Sure.
sure, once,
Appeared before the
once.
investigating officer and recorded his statement. The accused applicant is ready to, is cooperative and further ready to cooperate with the investigation. Therefore, the accused applicant, Sri Tagru Anand, may be released on, maybe extend the privilege of pre-arrest bail. Mr. Next para. Mr. D. Kamdu, D. Loy, learned public prosecutor. By placing the case there. No, referring to the materials on the case there, submits that. The present accused applicant has been arrested, interrogated, and recorded his statement under section 180 within bracket 3, bracket close of ENSS 2020, and subsequently released in view of as per the interim bail granted by this honorable court. Mr. The materials indicates that the applicant the accused applicant has sustained severe injury on his body during the alleged commission of the offense, and there and counter FIR has also been filed subsequent to the present FIR. Present FIR by the accused applicant. You are the one who has filed the counter FIR.
Yes.
Sure.
Yes.
Check it. He submits that as per the IM investigating officer, the accused applicant is fully cooperating the investigating agency by appearing before the investigating officer as and when asked to do so. Therefore, custodial interrogation of the accused applicant is not required at this stage. Mr. Next para. Mr. A. Bodo, London Council, representing the complainant. Come on. While seriously objecting the grant of bail to the accused applicant, submits that the victims, some of the victims are still in the ICU, and the victims have, the 6 victims have sustained serious and grievous injuries on their bodies due to as a result of firing and use of machetes during indiscriminate attack against the victims by the family members of the accused applicant, including family members of the accused applicants, including himself. Mr. He submits that some of the victims are still in a critical condition. Critical condition, and one of the victims is in the ICU. And one person has lost toes and feet. How? Lost is both the feet. Mr. Therefore, he submits that the clear involvement of the, and then since the clear involvement of the accused applicant and his family members are no, since there is a clear involvement of the accused applicant and his family members, accused and 21 others in assaulting by firing by using arms and methods. The applicant, accused applicant is not entitled to release on bail. Next, consider the submissions of learned counsel for the parties and also parents the case that the incident has arisen out of a simple, out of a land dispute between the family of the accused applicant and the villagers of Mania village on the other side. On the other side. It is seen that the accused applicant, along with his family members, have entered into the disputed land, and privacy appears to have used firearms and methods. Well, there was attack and counter-attack between the two parties. Next. On consideration of submissions of learned counsel for the complainant, learned counsel for the petitioner and the learned counsel for the petitioners, learned counsel for parties. It appears that both the sides, i.e., complainant side and the victim side, appears to have received grievous injuries to their bodies during their attack and counter-attack by using firearms and methods. Although the learned counsel for the complainant submits that some of the victims are in a critical condition and are under treatment in the ICU and have lost some parts of their body. Because of the attack by the accused person and accused persons them is not supported by any documents. However, in these proceedings for bail unless the, however, since in this proceeding, unless same is brought on record in the case diary or otherwise, this court is constrained to take a view on such submissions. Mr. Now, next paragraph. The investigation, the investigating agency has taken the investigation, which appears to be in right earnest, and the perusal of the case diary indicates that the accused applicant has been arrested, interrogated, and recorded his statements. The accused applicants also appears to have sustained injuries, grievous injuries, and an FIR has also been filed subsequent the present case by the accused applicant. Mr. Next paragraph. It is also noticed that the investigating authority, the investigating officer, in uncertain terms, that the accused applicant is fully cooperating the investigation by appearing before the investigation officer as and when called for. And as such, custodial interrogation of the applicant is not required at this stage. And he has assured to abide by all conditions. Mr. Next paragraph. Having considered the submissions of land counsel for the parties and also perusal of the materials available in the case diary, although the parties, both the parties have sustained serious injury as a result of the assault and counter assault between both sides due to use of firearms and machetes. This court is of the considered view that the applicant accused person is deserved to be extended the privilege of pre-arrest bail, particularly for the reason that the IO investigating officer has clearly stated that custodial interrogation of the accused applicant is not required. Mr. in view of the accused applicant, namely Sri Tagru Anand, is granted the privilege of pre-arrest bail. He is admitted to the privilege of pre-arrest bail in connection with so and so. Accordingly, the Sri so and so accused applicant, Sri so and so, so accordingly, huh? No, accordingly, the interim bail order dated 20, when it is
That's in,
11/04/2025,
um,
in connection with, Pauline PS case number huh, same, is hereby made absolute on the following conditions. That the accused applicant shall cooperate with the investigation officer and appear before the investigating officer as and when called for. Then that other condition, the accused applicant shall not tamper with this so and so. Then anything, any more conditions? Will not say filing of the charge sheet. The Naomi village.
a
What do
place
you
of
say?
incident, lots of place of incident, Yomi.
You don't
There's a-
go. You don't go.
So for some domestic work, I may go, but I'll never be.
Without the
in-
permission of the Ayo.
Maybe, I have no objection.
The accused applicant shall not visit the Naomi
Yomi
village.
place.
It's not your village,
Actually, that's.
Naomi
what-
village. What is the thing?
Actually, lots of.
N-O-
Place of incident.
NOAMI or EMI?
NYOMI.
NEO?
Yomi,
NE?
Yomi.
NE?
Some written as NEOMI and some is written
Which one is correct?
Yeah,
Give the correct one.
NEOMI, Yomi.
NEOMI
Yomi.
village without the permission of the investigating officer. Mr. Next one. It is made clear that any observation made in this made observation above is only for the purpose of consideration of the present bail application, and same shall not be construed to be on the merit of the matter, which is still under investigation. The bail application is still disposed of, allowed and disposed of in terms of all. Then what about second one?
Second is also the same.
Same FIR.
Same FIR and same incident, and this is also same. This is his sibling.
You are also your brother.
Yes, bail granted, and this pre-arrest bail granted, and
Same date.
same date and same. And
Yeah, I'll see you. Same names will be changed on it.
ground-
Same section, same
section,
FIR. I mean same
ground for prior also same.
case. Huh?
Injured, he also injured.
Injured also
Yes.
same.
Injured in
That
thigh.
same bone marrow came out.
No. Left thigh. Severely injured.
Okay.
Same medical.
Same.
Same order.
The CD be returned back. Return the CD.
But some same or
Yes, same order.
close.
Any other submission in item 7? Same. You also name accused.
Applicant, yeah, this is.
Tagru Mine also
Tagru Mine.
name the accused
Yes.
in the FIR.
Yes.
Oh, you have filed an FIR? Counter FIR?
Yes.
No.
Yeah,
You have also filed counter FIR.
Possibly he is a sibling, just sibling of this Tagru, and just same brother, same father.
They have filed what FIR that was prior to the incident was happened. In that case, this applicant might be as a but after the incident,
Anand filed FIR on behalf of me. I'm also victim.
but not in this.
You have not filed any.
I have not filed, but my brother,
Then that only that part,
Yeah.
counter-referred part, it should be different. You will see.
notes. But
Huh? Dispose, huh? Same, huh? Go. You can do it. It will take time. No, just give the case diary. She might have. You need the case diary, right? Huh? Just give the case diary. But I have said the return back, huh? After I put my signature, it will be, you take it back, huh? After my signature, you send it back. I give it back.
Okay.
Try to go for my Napoleon.
Time for the appellate.
Yes, Napoleon. Huh? What is this?
Lordship,
IA 4?
Lordship condemnation of deal.
Yes.
Lordship, on the last hearing, the notice was served. And on today is fixed for appointment of an amicus if the victim is absent.
Yes. Hard Mr. So learned counsel for the applicant
Yes, Your Lordship.
and Mr. D. Loy learned for the prosecutor. For the step. Yes. Registry. Is there any other? Huh?
Victim is not turned up.
See, hearing. As per the order of this court, that is 01/04/2025, MS Christina Ehring has been appointed as legal aid counsel on behalf of respondent number two. However, whether she has been communicated or not?
Lordship, he has been convicted, Your Lordship.
No. This appointment has been communicated or not? Is learned MS Christina Ehring learned counsel has been appointed LSC learned legal aid counsel as legal aid counsel on behalf of respondent number two. Mr. However, she remains. However, she has not appeared today. Mr. The registry to communicate the appointment of Miss Ehring as LSC. She might not have been communicated. Registry to send reminders for trial court records.
Maybe
List
listed
after 3 weeks. Huh?
1 week, Your Lordship.
List after 2 weeks.
Of pleasure. Lordship, there's a small prayer. In item number 4, there is an interim order that may continue.
Item number 4.
Yes, Your Lordship.
What is item number 4?
This is regarding setting aside of maintenance.
Yes. Item 4. Interim.
Of pleasure, Your Lordship.
What is IA? Huh? As respondent. Yes. Who is for petitioner?
This is a civil revision, yes.
Yes.
This is a civil revision petition. In the main case, he is not a party.
Hmm?
In the main case, he is not a party.
Therefore, he is seeking implement. Any objection?
Yes, I have an objection because he has no prima facie any material to show that he is a party in the case. He has to establish. He has to establish the case that he is a party in the case.
He is
There
not
no
a
mat-
party. That's why he wants to be a party.
Whoever maybe party as a party in the
Heard
case. I have
Mr. T.
included. Yes.
IA.
Yes, I am.
Heard Mr. Titang, learned counsel for the applicant, and Mr. T. Tapak, learned counsel for the opposite party writ petitioner. 2 weeks' time is granted to Mr. As spread for by Mr. T. Tapak. 2 weeks' time is granted for filing objection to the IA.
Already I have filed objection.
Yes.
I have filed
So,
objection. Yes, I've made a file objection. That is why.
then,
Already filed objection.
so what is to be done?
Matter may be disposed of
Okay.
as per merit,
Okay,
whether they have make out any case or not.
okay,
Because revisional jurisdiction before the revision court.
Yes. yes,
Petition pending then the NOC. Before prior to the petition required event, NOC was granted by the village community at Rampura. And thereafter, yes, equity. Now, in this figure, respondent number 1 to 14. What we have done is there in representing the Mabo village, the tribe. However, Lordship, it doesn't part of the disputed land in the instance civil division. The adjacent part has been distributed. Now there is an apprehension of the apprehension by the villager that if the order, implementing order passed by the Deputy Commissioner of Public is upheld, then the same fate will be again done by the respondent by distributing the land. So it is protect the community land. And here the applicant was representing the Mabo village as a whole.
you are what? Are you what?
So I am the president of the Mabo village youth around.
Okay, so this land claimed by the petitioner,
Yes.
it would
Say to the
community land.
Yes.
Include, then these people are there.
Lordship, exactly, Lordship. With that regard, Lordship,
Who are the respondents in the CRP?
there are some groups,
Huh?
some groups, committee.
They
were formed by themselves, and now they intend to represent the village. However, Lordship, in lieu of representing the village responsibility, they are distributing the community land. The other part of the
among themselves,
among them,
the respondents.
yes,
Okay.
the other part of the disputed land, Lordship, which is not in this current CRP document.
What is the okay? Then
If there is any prima facie material to show that they are a party, then
Or
that can
Mr.
be implemented.
Heard Mr. T. Tang, learned counsel for the applicant, and Mr. T. Tapak, learned counsel for the opposite party civil revision petitioner. Revision petitioner. By filing this application, the applicant has prayed for, has sought for implement as party respondent number 16 in the connected civil revision petition being CRP C number 55 AP 2023. Please stop. Mr. So and so, learned counsel. Your name is not there. Have you filed? What's your name?
T. Tang.
T. Tang. Next one. Mr. T. Tang, learned counsel for the petitioner, submits that the applicant is representing the village, Mabo village, wherein representing the Mabo village, wherein the disputed land in the in the writ petition, in the civil revision petition is located. Full stop. Although the opposite party petitioner has added as many as
14.
14 or 15
I think it is
15
15.
persons as respondents. Come on, they are claiming the land individually and not as a community land. Please stop. The land involved, the land in the disputed land, the subject matter in the subject matter, the land involved in the revision petition is a community land. Please stop. Therefore, the applicant is a necessary party and press for press for direction of press for allow the applicant to be included as party respondent in the connected revision petition. Next para, Mr. T. Tapak, London, counsel for the opposite party, public revision petitioner, while seriously objecting the implement of the applicant, submits that the applicant has failed to make out a case that he is I'll be there. My roster is after Monday, Wednesday.
So,
See your convenient day.
But I have no issue. Tomorrow and day after, we're better at Guwahati, that's why.
April, May, no? May.
Yeah.
Lordship,
Can it be on 7th?
7th May, Lordship.
Ah,
Lordship, I have a similar election matter on 1. Can it be fixed on 1?
1st
May. The others.
First.
It's as per your Lordship's
Okay,
convenience.
okay. Huh?
Not first of May, preferably why not on Monday,
And,
preferably on Monday.
30th, 30th.
13th, I need also to do.
क्योंकि हम लोग 1 or 2 या 2 belong.
13 or 14, 13, man. 13. I don't know if 12 is open in the principal city. It's open in principal city. 12.
No, principal seat, it's not. 13.
Lordship just saying
Why not on then 8, 7, 8?
Eight.
8. Yes.
Lordship,
8, 9, I'm there.
8.
8. Okay. Due to, we'll say, due to paucity of time, I think 23. Better could not be taken up. For hearing next bill, as agreed to then concept for the parties. Mr. A.R. Tata, concept for the election petitioner. And the point then concept for the respond number 1 and
Number 3.
a manager for respond number 3. List this matter on 8
Right.
08 05 20 25. Wherever it is, it will be.
Lordship.
It's better you because this IA has to be heard. So you physically
Lordship,
present
in that case,
wherever.
IS 72 may be disposed of because in IS 72, the return candidate, the applicant has just said that this instant IS 71 may be heard first.
I will
Then
see.
that can
We'll
be
see.
disposed
We're
of.
not hearing anything today. We'll see on that. So you come down to principal seat.
Probably my senior associate will come.
Who?
We fully.
Whoever is there, you inform them.
They can
It will be taken
video
up.
conferencing also,
taken
because
up.
the argument is between the
Yes.
and Mr.
The
Taken up
return-
here, physically. Wherever I am there,
Yeah.
even if it's IGL, we will to come.
Lordship, in other cases also, Lordship.
Kohima,
because-
I may be there, we don't know. All right.
Obliged.
Deeply obliged.